years. Judge Ulrich Hartmann deemed the Facebook account the same as that of a private diary or a letter, citing that digital content is no different. However, Facebook argued that this would breach privacy policies of not only the deceased but the third parties' data involved. Before the ruling, two options were offered by Facebook to relatives when a user dies, one being to turn the page to a memorial page or delete the deceased person's account. Well, does this judgment now pave the way to set a legal precedent around breaching privacy policies on social media? For more, we are joined by IP attorney and member of the South African Institute of Intellectual Property Copyrights Committee, Mr. Stephen Hollis. Very good evening to you. Thank you very much for your time. Essentially, does this judgment now pave the way or set some sort of legal precedent in isolated cases?
Well, Shante, it's a very good question, and it's a question that's at this stage not necessarily in South Africa, because what we need to remember is that it's a German court. It's a German constitutional court, and even there it was the matter went through the court of first instance, who actually found for the family to have access to to the platform, to her account, and then it went to an appeals court that ruled that data privacy rules actually should be considered as well. And Facebook's argument that it's not so easy just to open the account for the family, because it's not just her personal information that's on her social media platform necessarily.
Yeah,
that's what makes it so interesting. I think we've got a situation nowadays where, in the digital age, where lawmakers and also even the social media platforms are struggling to come to terms with exactly how privacy laws are developing. Users want to access information freely worldwide. So when you actually sign up for a social media platform such as Facebook, you do give them a license to use your content in certain specified formats and specific ways, but you also expect of them to keep your data private. So the very interesting thing of coming from this case is we know what happens when you're alive, but what happens when you pass on?
Yeah.
So the German Court have found, in these very special circumstances, where I think what played a role potentially is also the fact that we are dealing with a very emotional case, the death of a 15-year-old girl, who was a minor. So many would argue that the parents of a minor should have information on who she was communicating with before her death, especially if there's on their side some suspicion
of suicide.
Yeah. We know of examples where teenagers have committed suicide because of peer pressure, social media peer pressure as well. So it's a case that involves so much, and in the end, the Court sort of found the answer in their inheritance law to say that the contract would in fact devolve into the deceased's estate, and her heirs, which were parents, would have the right to demand that Facebook actually gives them access. A thing that we do need to remember is that Facebook is not the big enemy here. What they're trying to do, they've come under immense pressure recently. We've all seen Mark Zuckerberg standing in front of the Senate explaining how Facebook used data. And in some instances, criticism as to how data is used and concerns, are valid. But we must also remember that when you sign up to one of these platforms, other users' information would also be accessed. So in a case like this, where you allow the account to be opened up, it's not just the deceased. So I think the court, when they compared the online platform or the profile with a series of letters and a diary, a personal diary, was perhaps not really keeping in mind how the digital world has changed all that.
Yeah.
So you're in fact looking at other people's disclosures as well. And when it's not a case limited to these particular circumstances, I can think of many instances where a person would not want their families, after they pass on, to have full access to all of their social media platforms. This decision, if it's followed by other courts, would not necessarily stop with Facebook. It will go to Instagram, Twitter, etc. So where do you draw the line? Must you exclude from your testament, your will and testament, that your family should not be able to access your information when you pass on, your views on all sorts of private things, whether religion, politics, sexual orientation, etc. You can think of maybe families where you're not that close to your family members and you don't want them to access your data.
Mr. Hollis, we are pressed for time, but let's just discuss how this case is different. We actually go back to the Oscar Pistorius case and the huge drama in trying to access his phone. And Apple, when they were contacted in the States, was saying, no, we're not going to give you access to the phone. We're not going to give you those PIN numbers. Where does now social media begin to draw the line between law and criminality or a crime scene, a court case, and of course their privacy policies that they have and the protection thereof of third parties?
Well, I think every case will be deemed and should be looked at on its merits. I'm not so sure what happened in the Oscar matter with the cell phone access, but in 2016 I do know that Apple was involved in another in an issue where the FBI sort of accused them of not cooperating when to unlock the phone of one of the two mass murderers of the San Bernardino shootings. But there's so many other things at play. In that particular case, Apple found that to unlock that phone, they needed to design what they call a master key, which key could be used to potentially unlock any phone, any iPhone. So that could introduce a security risk for all phone users. So if they disclose that information to the police, it's almost for a big business. You can imagine, let's say somebody, argument's sake, the last demand to know what the secret ingredient in Coca-Cola is, because they need to determine the last drink they had before they got sick was a Coca-Cola. So for Coke to disclose that information could harm their business gravely. But in the end, it will come down to a case-by-case basis, and these companies are responsible companies. So in their terms and conditions, it does state that if there's a criminal investigation or maybe a crime was potentially committed, they may use the data, they may work with the police to actually grant access to the data. So that's where we are with that.
Thank you very much for your time this evening. Unfortunately, press would love to have carried on with that. Thank you very much for your time this evening. IP attorney Mr. Stephen Hollis on that German court ruling of giving Facebook user access to the parents of that 15-year-old girl. That is a wrap up from my side. Over to your side, France.